or whether it be a shooting, um, uh, the analysis necessary that would go into a murder investigation or into a shooting investigation is pretty much the same that we do in investigating our cases. And so they're fact and witness intensive. Now, negligent security cases are extremely involved. I can tell you in a death case that we had most recently, I think we had 27 depositions in that case. And so they're not they're not quick cases, but they are very interesting. And those of you who are working in the public defender or the state attorney's office will have some experience that will be translatable to a negligent security case. And then finally, I think as African American lawyers, many of us come from the communities where these cases occur. Let's just be candid about it. And most of us know folks who live in depressed communities. Our family may have lived in a depressed community, and those are places where these cases happen. And in our experience, we have found that many times the defendants in our cases put profits over people. And as a result of that, we can easily convince a jury that more should have been done in order to protect the residents of our communities or the persons that were injured. And so, but let's face it, the Rouse firm is a personal injury and wrongful death law firm in the business of making money. And so at the end of the day, these are some of the more lucrative cases that in my practice that you will come about. And I think that our friend Relly B will tell you precisely why we handle these cases.
What a money reside, what a money reside, what a money reside, what a money reside. The what a money reside.
And so as a result of that, we handle negligent security cases. Now I'll turn it over to Imani.
Excuse me. Hi, good afternoon, everyone. Again, my name is Imani Williams, personal injury associate at the Rouse firm. I've had extensive experience working in automobile accidents here and have touched several negligent security cases. So I'm happy to be here today to share with you guys my insight and just my perception on what a negligent security case is all about. And also, if you guys have any questions while we're talking, feel free to share it in the chat and we will be sure to get back to them as soon as possible. So what is a negligent security case? In Florida, there's a special area of law that provides help to those who have been injured either on a commercial or public property due to lack of security during the commission of a crime. And these crimes can vary from assault, battery, rape, manslaughter, and murder. Under premises liability theory, when an invitee is injured while on the property, they have a right to recover damages. This area of premises liability is known as negligent security. Under the premises liability theory, a property owner has a duty to protect a plaintiff from third-party conduct if that defendant or property owner has actual or constructive control of one of the following: the instrumentality of the harm, the premises upon which the tort was committed, or the tortfeasor, which is basically the person who committed the tort. And since negligent security falls within the auspices of a premises liability, its standard of care is passive negligence, which means that the tortfeasor failed to do something, versus active negligence, where a tortfeasor actually committed something. So, why is a negligent security case so important? A negligent security claim is essential because criminal cases oftentimes don't provide the adequate compensation a victim truly deserves. So, with the negligent security claim, a victim or their loved one can recover money damages such as lost wages, pain and suffering, or even long-term medical needs. Also, it's important for our economy in Florida because, or at least it should, it provides an incentive for property owners to provide adequate security to protect us all. Determining a cause of action. Unfortunately, just because a party is injured on a property does not mean that they automatically have a viable cause of action. As previously mentioned in the previous slide, the status of the injured party is imperative in a negligent security case. This is because the only duty a property owner owes to an undiscovered trespasser is to refrain from intentional harm. And the only duties a property owner owes to a discovered trespasser are refraining from intentional harm, gross negligence, which is reckless disregard, and they also have a duty to warn of dangerous conditions that aren't readily observable. So I want to give an example to kind of illustrate the importance of status in a negligent security case. So we had a case, or so I thought, in Stony Brook. It was a shooting that dealt with the robbery. And during the investigation, it was discovered that the injured party actually willingly told the police officer that they were on the property selling drugs, and the person that they were selling drugs to shot them. So automatically, the status as being an invitee is ruined. And this is why it's important to have investigation early on in the case, because it can really make or break your case in negligent security. So this is important too, because you can rest assured that the defense counsel is looking for holes in your case, because typically damages are going to be there. The person is injured, so we know the damages are there. But it's always on the defense side to try to figure out a way to find out how their client or the property owner was not liable. So that's just a good example just to show you how status is a big piece in a negligent security claim. But back to the substantive law of negligent security. Under Florida's negligent security law, a crime victim can recover if they can prove all four of the following elements. 1, a dangerous condition existed. 2, the defendant knew or should have known of the dangerous condition. 3, they failed to take reasonable steps to correct the dangerous condition and make it safe. And 4, the plaintiff was injured as a result of the dangerous condition. But if it is found to be a cause of action and that there was a duty owed, a property owner can breach his duty to exercise reasonable care through several acts of negligence. To name a few: failing to adequately train their security guards, failing to have visible surveillance cameras to deter crime, failing to assess criminal activity trends going on the property, and failing to have adequate lighting in the parking lot and common areas of the property.
So the way we are able to, the two main issues that we encounter in these negligent security cases are always notice and foreseeability. We're able to establish notice by, for the most part, which is the standard in almost every case you have to go that we try, is through prior similar crimes. There are jurisdictions that require prior similar crimes. There are also jurisdictions that allow prior predictive crimes. And I'll explain the difference shortly. But the way we are able to show prior crimes is we pull what is called a crime grid from local law enforcement. And so what whenever they get a call for service, they have a computerized record of that call. And if the call is something significant, they then will create a police report. So we pull all of the crimes for a particular property, and then we ferret out those crimes that don't have any pertinence to our case, and we try to get the ones. So for instance, you have a rape case, you would want any rape case in an apartment complex, for instance, you would want any breaking and entering to apartments. You would want any actually loitering calls to an apartment. You would want any other rapes, of course, and you would want any other crimes that that could have devolved into a rape. So we pull the police reports, we review those, and we likewise, in a number of the cases that we handle, we look at the industry standard. Shopping centers have industry standards on the way that they should be maintained and they should be monitored. We examine whether or not the shopping center and the location of where our incident occurred is operating in accordance with the industry standard or the community standard. We may look at a similarly situated shopping center and another within a very close proximity to our case and see, well, this shopping center has 5 security guards or 24-hour security guards, and our shopping center doesn't have any. And so we look at the community of where the property is located and make an assessment on whether or not another similarly situated property is pertinent to being able to prove our case. At the end of the day, one of the in apartment complex cases, one of the greatest places to find information is within the tenant files. And defense lawyers always want to fight us on getting the tenant files, but when we get them, they oftentimes offer some pretty significant gems. In the case that we mentioned at the outset of this discussion today, was a punitive damage case I got down at Miami Gardens, Carroll City Gardens apartment complex. Now, I had sued this apartment complex 14 times. I had 5 wrongful deaths, all as a result of people getting shot at this apartment complex. And the last case that we handled, and we're involved in one right now, as a matter of fact. So I've lived in this complex almost 15 years now. But in the case where we got the punitive damage, it was a 36-year-old mother who was out sitting on her stoop, minding her business when some gang members decided that they were going to have a shootout, and she was struck by a bullet and killed. Well, when we pulled her tenant file, we saw that she had written management, advised them that the lighting in the common area and around the apartment complex was insufficient, that she was fearful because she was hearing nightly gunshots, and that she felt that they needed to provide some security out there. Well, I think you can see what would happen when a defense lawyer gets a letter from the grave 2 weeks before a person gets killed. That case got resolved soon after we received that tenant file, and we advised counsel that we were going to be seeking punitive damages. Additionally, they may have security out there, or the appearance of security. Here again at the Carroll City Gardens apartments, I've been going there now over 15 years, and they have a guard gate. They have what used to be operational guard arms that restrict people from coming onto the property. Well, they haven't worked in the 15 years that I have been suing these owners, and so the having those security facilities available but never ever using them or allowing them to go into disrepair is just another notch in the belt of being able to prove that these defendants just didn't give a damn, to be frank with you. And you know, one of the other places that we commonly find information, and defense lawyers fight us again on this, is in personnel files. And where we look in personnel files and/or we look at the mode of operation of a business and whether or not that business is operating in a safe manner. So for instance, I know most of you have probably bought a sandwich at the Subway store there on Palm Beach Lakes and Forum, right across from the outlet mall. But many years ago, we had a young lady, a 16-year-old who was working there, and she was shot and nearly killed by a 14-year-old assailant. Well, when we pulled the tape, the videotape of the shooting, and we see what happened, the police had found that these folks ran from the subway there on Forum over to the Stony Brook apartment complex. Well, when they got there, they met up with two young ladies who used to work for this subway. And then once we did a little investigation, these young ladies had worked at the subway on Forum. They had worked at the subway on 45th at the flea market, and they'd worked at a subway over on Military Trail where Food Town is. Well, guess what happened to all those subways? All of them had been set up and robbed, and these women were somehow involved in each one of those robberies, but they couldn't prove them. Well, what we learned in terms of the mode of operation of the subway is that none of the subways talked. They didn't do background investigations. They'd hire you on the spot. In fact, in the case on Forum, the young lady who set this robbery up was hired that Friday, and she robbed the place or had the place robbed on that Sunday. So we were able to mine from her personnel file and learn that this woman was a serial, I guess, co-conspirator for robbery, and we were able to use that information in order to get a nice result for the young lady that was shot. Now, who are our defendants? Each one of the defendants in here are all the folks that we have sued over the years, whether it be a hotel, whether it be shopping centers, strip malls. All of them have a special, I guess, niche security aspect that you have to look at. In hotels, it generally is the access to the key control, because we get a lot of assaults and robberies and rapes in hotels. In strip malls, it's tenant mix, it's not having a way to control people from just coming onto the property. And you know, Albert Wallerman is here with me today, and we had a case up in Tallahassee where a young lady was walking from the parking lot to the nightclub in up there on Pensacola Street, and caught a stray bullet in the parking lot, nearly killed her. And what we were able to find, and I think what Albert would probably tell you, is that it was probably an extremely deceptive looking complex, because if you were to look at it, you would never have known all the crime that was out there. And so when we pulled those crime grids, as I told you before, they painted a story of this shopping center that one would never have known existed, but for pulling the police reports. And so we are big advocates on getting as much information, sometimes more than what we need, but we are big advocates in making sure that we get all the information and data available. One of the other things that we try to get is a lot of cities, Tallahassee being one of them, they do free security surveys. Security survey is where law enforcement goes out and they tell the property owner or the management company, well, here are some of the things that you need to do based on the threats that we know exist on this property. And so we try and those things are you know, a lot of defense lawyers don't know this, and I'm gonna give them a little nut today. They are under statute not discoverable, but most defense lawyers don't know that, and so they send them to us anyway. And or the city sometimes slips up and sends those to us, and they will outline for the most part any and every security defect that this entity may have, and of course we then expound upon it through our discovery. We use a.
What is it that's not discoverable? I'm sorry, I didn't catch that part.
The and you need to wait till the end of the end of the seminar, son. But security surveys are not discoverable under Florida statute. But at any rate, the liability experts we use are the criminologists. I have used several different criminologists, um, and they aren't cheap. I'll tell you that straight up. But what they are able to do for you is to give you an opinion that will, in most instances, get you over a Daubert objection on the foreseeability of the crime involved. And they likewise can, if you hire them early on, can assist you in giving you direction in the discovery that you need and give you some pointers on items that you may not have thought about in terms of angles that you could use to establish liability. One of the things I learned from one of my criminologists was to go and get the reports from the code enforcement. Many times code enforcement will have cited a property, especially apartment complexes, where they have a secure perimeter, but the perimeter remains in disrepair. And so we look for the code enforcement citations in order to be able to establish that they are not even maintaining the basic security facilities that they normally, or that they had in place. And that assists us in being able to establish liability. And finally, one of the things that we don't list here is that we use the geographic information systems and criminal mapping. A lot of the police reports now have, police departments have started doing criminal mapping. And what you can do is through a GIS system, you can take a Google Earth photo of a location and then have them lay over that location all of the crimes that have occurred on and near the location of your incident. And it's a very compelling exhibit at trial. It's interactive. It moves. It keeps, as we who do these things and try these cases, jury's attention span is shorter than a gnat in these times. And so to keep it as crisp and moving is necessary in order to continue to have the jury's attention. Now, these cases ain't cheap. I'll tell you straight up. I can't remember a case that we took to trial that we weren't in anywhere from $70,000 to $80,000. Our criminologists pre-trial generally between $15,000 and $20,000 is what they want. If you're taking 20 depositions, I'm sure those of you who've had in private practice that are paying for those depositions know how much they cost. Our trial exhibits, our jury consultants, should we go to trial, are expensive. And so we certainly have, you got to be in it for the long haul. And I'll give you a war story, and I'm not prone to do that, but we had a case where it was a young man killed here in West Palm Beach at an apartment complex. And we had defense lawyers that we felt that they were more about trying to continue to tap on the insurance company than they were on trying to make a reasonable settlement. And so they offered us, I believe, $250,000 for our client prior to trial. And in Palm Beach County, if you know that a trial is going to be 10 days or more, they make you do a summary jury trial where you pick two juries and you give an abbreviated opening statement, and then the jury comes back and gives you a number. And that's supposed to bring you closer together. I think it works better for defense lawyers than it does for plaintiffs. But both of the juries, one jury came back and gave us 0, and the other jury came back and gave us 50. And so, of course, they took the $250,000 offer off the table. And so we really had no choice but to try the case because we just weren't going to take $250,000 to settle this case. And we were, at the end of the day, $100,000 deep on that case. The jury did come back with a $3.3 million verdict, but we, you know, you got to be ready for the long haul, and so it's not something for the weak or timid at heart. But as I say at the bottom of this slide, we are always looking for referral relationships. And one of the reasons I do that is because many times those of us that do these on a regular basis, and this is probably an area of our practice that we concentrate on, sometimes you get in your own rut. And I can give you a story about a lawyer here in town that had a case at at the same defendant that we were suing, an apartment complex, and he came to us and wanted he was not as far along in discovery as we were, and we had done a hell of a lot of discovery. And in all honesty, I had missed a document that when he came, he asked me, could he come and look at the discovery that I had, and I was like, sure, come on by. And he came by and was going through our documents, and he goes through the manual of the owner of the property. And in the manual, there was a document called Never Say the S Word. And that's what the owner of this apartment complex, 300 unit apartment complex, had told all of its management personnel, is that if a person comes looking for an apartment, never say the S word. And so what we were able to do is to take that document and blow it up for trial. And we were able to show that the vast majority of the residents of this apartment complex were single women with children. And the owner of this property thought it was a good idea to hide the ball on the fact that they had had multiple murders and shootings at the property, and told their employees to conceal the fact, if asked, that there was no security, or that there was a crime problem on the property. And so they said, never never say the S word. And so my philosophy has always been that you get more with an open hand than a closed fist. And so I always will share and commiserate with lawyers who may have one of these cases or wants to bring us on, because I gain more by doing so, because it keeps me alive and keeps things fresh for me as well, especially when you get some fresh eyes. And so we've done fairly well over the years. We've had, as we said, jury verdicts in excess of $3 million, and many of these cases have settled in the high $500,000 or more. They are lucrative cases. They are expensive cases. But I think that of all the areas of law that I have practiced, they are probably the most rewarding, because we are able to make those who put profits over people pay, and do some good in the hood. Thank you. I appreciate it. We'll entertain any questions that you all may have.
We do have a question in the chat. And the question is, after receiving the initial $50,000 settlement offer, while simultaneously being $100,000 in the hole, what is your thought process when deciding to continue to pursue the case?
Well, in that instance, we didn't think that the offer was in good faith. We felt that that offer was being made because the defense lawyers were a young defense firm and they wanted to keep the tap going. Ironically, that proved to be the case, because midway through trial, the insurance company hired another firm to come and watch the trial, and actually be a second set of eyes, because they got the feeling that they weren't getting the square deal from their counsel. And so, we didn't really have a choice. When you offer a person $50,000 on a death, you're telling them that you want to try this lawsuit. The only way you would not try that case is if you had some significant warts. But I don't see a situation where I would settle a case for $50,000 on a death.
Thank you for that. I'm going to turn it over to Veronica. She has the CLE information. And she'll put it up on the screen.
Okay.
And thank you guys so much for presenting today.
Thank you.
I learned a lot. I had never known anything about negligent security except for, the usual, well, I guess I don't know if it's considered negligent security, but the slip and falls, you're in your grocery store, something's wet, there's no sign, you fall down and you break something.
So the next
That's what I'm used to.
So the next time you hear somebody getting shot on a property, don't think it's oh well, the shooters are the only people that can be responsible. You need to get a rouse from the call and let us look at it.
Okay.
All
I
right.
think Veronica might be having a little bit of trouble. So let me put up the CLE information. All right. For those of you guys who may be listening.